Hello and welcome to Legally Speaking with me, Tarun Nangia. A bench of Justice K.V. Vishwanathan and Justice J.B. Pardiwala have shown great concern over the state which insolvency and bankruptcy codes implementation via the National Company Law Tribunal has landed itself into. And they have said that thousands of crores are at stake and there are enormous delays. Delays like 363 applications seeking approval of resolution plans are pending, with delays ranging from 48 days to 738 days, which is well over 2 years. And in certain cases, these delays have stretched to 4 years, which is more than 1400 days. That is the precarious situation that the implementation of IBC, a good law with good intent, has landed itself into today, where people are fearful before they sort of even think of engaging in the insolvency process. And the two judges of the Supreme Court, namely Justice Pardiwala and Justice K.V. Vishwanathan, were pained to see the state that the IBC has landed itself into. Today, we're going to discuss this issue with two people who do a lot of practice at the National Company Law Tribunal and are aware of the problems that the promoters who are sort of looking at a speedy disposal of cases through the insolvency process facing. I have with me Advocate Mahesh Agarwal, Ruby Singh Ahuja, who's senior partner with Karanjawala and Company, both at the Supreme Court and NCLT. Good to see you. Thank you for your time.
Hello.
Thank you. At the outset, let me request Ruby Singh Ahuja, senior partner with Karanjawala and Company, to give an explainer before we move into comments. Over to you, Ruby, for the explainer.
Thank you, Tarun, and good evening to all of you. I think it's a very, very important topic which both Justice Pardiwala and Justice Vishwanathan has taken. And I can tell you with some amount of practical experience I've had there, the basics have become an issue at the NCLT tribunal right now. The basics, there is a problem of infrastructure. The basic infrastructure is cracking there. There are problem of vacancies, which leads to the situation where we are today. The tribunal doesn't even have the, I will say, brick and mortar infrastructure. If you see NCLT Delhi, 2 or 3 courtrooms sit in one building, other courtrooms sit in another building. There have been issues of electricity there. There has been issues of electricity, parking, waterlogging, everything. Now coming, so what happens that because there are a lot of vacancies for some reason, I don't know why, the judges are cannot sit at one go from 10:30 to 4 p.m. So judges are sitting, it's not for no fault of theirs, they have to sit from 10:30 to 1, then at 2 o'clock they are in another bench. So there is no continuity also. You don't get a good stretch to hear an important matter. And remember one thing, Tarun, NCLT has 2 important jurisdictions. One is the company law and one is the IBC. Then there is another problem because of this vacuum which is there as far as the vacancies are not filled. The tribunal sometimes the benches also change frequently. I've had a situation where one of the honorable member is sitting in Delhi, one of the honorable member is sitting virtually in Chennai, if I remember correctly. Now what's happening that even a normal conversation to issue notice or not is taking 20-25 minutes. So I think today the situation has come that unless and until we look into we don't have to, find out as to is there any amendment to the act required, what is going to happen. That is a very, very, that is right now even not required. We need to fix the basics. If you give you will have to give the infrastructure to the tribunal to function. Otherwise, it is going to crack down, that nothing will happen. And I for a minute don't blame anybody working there, because I can tell you they are working in very extreme circumstances right now. I mean, if you compare the infrastructure to basic civil court infrastructure in Delhi, that infrastructure is far better.
Okay.
So I think the government really needs to look into this, and you don't need rocket science to fix it. It's certain simple steps will fix this. So I'm very happy that the Honorable Supreme Court is looking into it. Otherwise, this act will fail.
Okay. Point very well taken. The act will fail if the things are not sort of now course corrected. And the bench also said that taking suo motu cognizance, this should be referred to the Chief Justice of India and a larger bench to take corrective measures for NCLT to be functional again. Of course, now this will be before Justice Suryakant and the bench. I want to ask Mr. Mahesh Agarwal two things. Uh, they are saying that the law may not be broken, but the system around the law has broken. That sometimes the diagnosis of the case is too simplistic. While the legislation is fundamentally sound, the machinery responsible for implementation has completely collapsed. The tribunal is itself overburdened, vacancies are unfilled, hearings are stretching endlessly. Resolution plans uploaded by creditors wait months and sometimes years for judicial approval. Many times they say that the business case itself becomes suspicious or not relevant for the promoter. If it takes 2, 3, 4 years, the promoter loses interest in the case. Do you think the court has now started frightening the borrowers more than helping them?
No, so I think number one, we are very happy and very glad that the Supreme Court has taken up this issue. It's a live problem and we are facing it on a daily basis. If you see the object of IBC, but one of the main object was speedy justice. Before this, a bank used to file a case in DRT and wait for 20 years for recovery. So this was a very essential legislation
Correct.
to get recovery of monies, public monies, in a fast-tracked manner. That was the main objective. But that has now currently completely failed. So multiple reasons. One is, I would say, the quality of judges. The idea for tribunalization is to have experienced people who have done company law. Now we have people who have seen company law for the first time and they're sitting there. So it is a disaster completely. Secondly, like Ruby mentioned, a lot of infrastructure issues. As a result, what is happening is all stakeholders, promoters is when a resolution applicant comes and he wants to take over a company. But before that, the banks who initiate insolvency, they have to wait for several years for a resolution. The promoters of the existing company, they are unsure as to what is going to happen with the company. The resolution applicants, they keep contesting, and the bonanza is reaped by the COC and the RP. The RP is de facto running the companies during this time, so they are in no hurry. This issue has to be fixed at the earliest. Otherwise, the right thing to do is the act should remain the same, the provisions of the act should remain the same, and the jurisdiction can be given to the high courts. There is no purpose of transferring a jurisdiction from the high court to NCLT or NCLAT for the purpose of speedy justice and later on realize that high courts were better. Today, something which can be done by the high court, why should anybody go to NCLT? So this problem has to be fixed in a holistic way. I'm not saying that NCLT should be shut down, but until and unless some extreme measures are taken, timelines are adhered to, penalties are imposed, it won't work.
Point very well taken. In this case, senior advocates Naveen Pava and Gopal Jain were the amicus, but now this is being referred to a bench where the Chief Justice of India is going to hear the case. I want to, Ma'am Ruby Singh Ahuja, I want to get your comment on this, that the creditors are quietly leaving the IBC process. If you look at the latest numbers that are released by the Insolvency and Bankruptcy Board of India, during the financial year 2025 and 2026, only 665 corporate insolvency cases were admitted. This is the weakest performance since the code came into force. And if you take the comparison of 2022-23, admissions were around 1250 plus. So you had 1262 admissions and now it's just 665. So more than half, more than 50% collapse we can see. Do you think that the distress in companies has not disappeared, but the forum has completely got impacted and people are losing faith?
That's right, Tarun. I call it a stakeholder fatigue. There's a fatigue which has set in because now what has started happening, forget the resolution plan being approved. It takes time to even get an order on your simple petition under Section 7 or Section 9, whether the tribunal is accepting it or rejecting it. So, at each step, if a creditor has to spend time, it's not only time, it's also money, it's also human resource. Then you feel that, okay, fine, There is no point my getting into and standing in queue and waiting for 2 years. By that time, there is the asset value of that corporate debtor has anyway eroded to a very, very large extent. The fatigue has set, the money is being wasted. So creditor maybe wants to now look the other way around. And maybe, I don't know, may do a one-time settlement on its own. So that is the problem. And what happens that once you admit it into insolvency, you have not approved the plan. There is a moratorium which is set in. Now the creditor, anyway, the other creditor can't do anything. So I think it's not that the delay affects one creditor, it affects the whole system. It is not this needs to be fixed. Otherwise, yes, the legislation is a robust legislation, but I think the time has come to see how we practically implement it. If we will not, then I think it will lose its value sooner than later. This is a genuine problem which is there, and I'm very glad and I'm hopeful, and I'm quite hopeful actually that it has gone before the Honorable Chief Justice, and the Honorable Chief Justice will look into this whole issue. It
Point.
must start first by filling the vacancies which are there and giving a basic infrastructure. If I'm not wrong, somebody told me that the people who are doing at the registry level are also on contract. I've not checked it myself, but somebody told me this. So you need to have trained people there who can do this in a very fast way, like you have in the High Court. Otherwise, what's the point of giving it to the tribunals? Mahesh is right. Then either we bring it to our various High Courts who are competent to handle this then.
Point
Another
very well.
important jurisdiction with NCLT is on the company side, which is mergers and acquisitions. Now, mergers and acquisitions through a scheme of arrangement is very critical for business, and most of these matters are time sensitive. When they used to be in High Court, we could assure the client that in 45 days from start to finish, we can get you a scheme approved. Correct? Now that 45 days has become 6 months to 1 year. So the entire scheme, when you have a scheme for arrangement, it is very, very important that within a particular financial year or before your next balance sheet time, that the scheme is approved or rejected, whatever happens. So time is very, very essential. There have been so many cases that merely because of delay, the schemes have been withdrawn, that we cannot wait forever. Now, a scheme for arrangement or a merger or acquisition is critical for business growth. One of the main mantras of the government has been ease of doing business. Now, this is an essential part. This is also with NCLT. Now, so what I'm trying to say is IBC and resolution is one part, but there are multiple issues. For example, I told you merger acquisition. Second is operation mismanagement. Earlier, we used to file a petition. If you are getting oppressed by a majority or whatever, you file a petition, you will get a result in 6 months to 1 year. When Justice Bala Subramanian used to be there in good old times, we used to get decisions in 1 year. Now the operation mismanagement takes 5 years.
Mr. Mahesh Agarwal, I want to ask you, between you and Ruby Singh Ahuja, both of you deal as clients with some of the top promoters of India. And I think you also have to sort of suffer the complaints from them in terms of why these cases take so much of time. And I want to point out that time is literally destroying value at the IBC. The cornerstone of this bill, when it was turned into law, was speed. That is what was spoken of in Parliament. We want speedy disposal so that business can continue. Parliament, in its wisdom, prescribed an outer limit of 330 days for completion of insolvency proceedings. Reality now bears very little resemblance to that ambition. The average insolvency case takes about 744 days. That's like 2 years. Now, this is not a minor delay. It represents a complete collapse of the statutory timetable. Business cannot remain commercially healthy while waiting for more than 2 years for legal certainty. In some cases, it is worse. If you take the Jet Airways case, it went on endlessly for years without any. So I want a comment from each one of you that on the timeline front, do you think a complete overhaul is needed?
No, so I would say that the act is well structured. The rules in place are absolutely fine. The problem is with infrastructure and the people handling it. So from the Parliament side, I don't think we have any complaint with the structure of the IBC or the acts or the rules or the regulations or the procedure. It's all fine. The time limits which have been imposed are also fine. 330 days is a very good period to resolve a company. But to be able for NCLT or NCLAT to comply with these timelines, they need a paraphernalia, they need infrastructure, they need staff, they need judges who are sitting on time, they need a proper courtroom. That is what is missing. So from the parliament, we have no issues at all. The law is absolutely fine. The issue is at the implementation stage. So what has to be fixed, I'm sure it will be done by the Supreme Court now, is the implementation of the act, which has failed the object of the act.
Point very well taken. I'll go to Ma'am Ruby Singh Ahuja. Now, businesses cannot remain commercially healthy when they wait for 2 years for legal certainty. If you see, if it takes 3-4 years for closure in an IBC case, it also goes to Supreme Court. Factories, they deteriorate. Key employees leave. Customers shift to competitors. Very difficult to get them back. Technology becomes obsolete. Enterprise value also evaporates. And they say that every additional month that a company is in insolvency, the chances of revival become very bleak. Do you think that we are now arrived at a situation that the Supreme Court will have to take the bull by the horns and completely overhaul the working there at NCLT? By, of course, when you said that there should be vacancies that should be filled, what all you think needs to be done so that the investor confidence in the IBC remains?
Tarun, as I started, you have to give the basic for a judge. You'll have to give him a courtroom with a working air condition at least to sit.
Correct.
I have been in tribunal and tribunal could not sit because the internet was not working.
That basic a problem?
Yes. And I am saying it with some level of experience and being there. There has been a day where I was there in a matter where there were top senior counsels of the country in that courtroom in peak May heat. And the only thing we all were expecting that the court should now rise because we won't be able to breathe here. So
That's
you have
the situation.
yes, you have to, because I'm telling you, that is a reality and it can be checked. You have to start with the basics. Once you start with the basics, which is not difficult. I mean, I think that is a half a day job for any government to do this. And secondly, you fill the vacancies. And thirdly, very, very important, please bring domain experts. If
That's
you
important.
want this to work, you please bring domain experts who know there are cases which are happening. Forget time being spent in getting a resolution plan approved. I have had promoters who are suffering where the plan has been approved, money has been paid, and now there are 100 applications filed that their plan should be opened. You're also spending money on that. Remember, a promoter is spending money on contesting that application, and the tribunal is wasting money in hearing that application, wasting its own judicial time because they have to hear that application. So maybe domain experts, maybe better training, maybe sensitizing to the judges that, there are certain issues which are already barred under the court. The Supreme Court has also said that the resolution plan will extinguish your debt. It's a very simple, it should be applied uniformly. But so what happens if you don't bring domain experts? If you keep on changing, the roster keeps on moving, the delay will keep on happening. It is not difficult to set it. It is very easy. Somebody just needs to spend some time and it can happen.
In fact, I'll tell what businessmen said as to what they understood of IBC, that this is your tribunal to rescue viable businesses and give them to new owners who can now run them after paying the debts. But if you take the statistics, 9,000 insolvency cases have been filed, admitted since 2016. Only 1,419 companies have emerged through this with approved resolution plans. 3,000 companies went into liquidation. And around 1 in every 6 admitted cases ultimately achieve the objective of corporate revival. So it's 1/6. I go to Mr. Mahesh Agarwal on this. Do you think that the aim is not sort of being fulfilled and the objective of having a tribunal has failed?
No, I fully agree. The whole objective was to revive companies. The word is resolution. Resolve the debt, not bring about liquidation. The objective of the act is not to liquidate companies. The objective is to continue the business, continue employment, continue revenue generation, continue payment to the state exchequer. That's the purpose. The business should go on. But what is happening is that possibly either because of the delays or lack of interest or lack of confidence of new promoters to come and apply for a resolution plan, that companies are ending up in liquidation. There are so many cases where we have seen that the company is doing pretty well and the company could have been revived, but there are no takers.
Point very
Why?
well
Because
taken.
people are not interested. If a message goes that if a company is in IBC, you make an application, you will get a result in 6 to 9 months. The number
Yes.
of people applying for such a thing will be obviously too much.
In fact, I remember
The
it's a
purpose is
matter.
failed.
In fact, it's a matter both Mr. Mahesh Agarwal and Ma'am Ruby Ahuja dealt with. If you take the case of Sajjan Jinjal's JSW, they had so much of trouble getting Bhushan Steel assets right up to Supreme Court, and then the ED also was claiming an asset. So promoters don't have it easy when they even win, through the NCLT and NCLAT. But that's another story. I'll go to Jet Airways is not an isolated example. When Go First, which is also another airline, entered into insolvency in 1 year, it was seen that insolvency will your liquidation will become inevitable. Go First didn't go to a new owner. It was it's going into liquidation. Videocon Industries has remained trapped in prolonged litigation, and manufacturing assets of this company have completely got eroded because of so many years. No, so creditors, if you see, in many cases have recovered less than 5% of the total outstanding. Do
So
you
that's
think?
what we're saying. The speed, therefore, is essential for resolution.
Correct.
The objective is not to kill the company. Objective is to resolve the company and carry on with the business. If a time
Correct.
limit is given and assurance is given to a promoter to make a bid,
Right.
today people are scared going to NCLT to make a plan because
Correct.
there's so many uncertainties. How much time you will have to spend, how much expense you will have to incur, for how much time you'll have to keep your guarantee alive to remain a bidder. And
Right.
after you get the company resolved, then how many applications will be there to reopen and the
Correct.
appeal process. So people are scared coming in. If the people are
Correct.
scared, then obviously it's going to fail.
In fact, when it started, if you remember, Mahesh, when first the RBI came up with that circular and Bhushan Steel and SR and all went into insolvency, and that time the speed was an essence. Everything was done very expeditiously. But I don't know, down the drain, we have now forgotten that the time was essence in this sort of a, which is a very important code for the economy of the country. But we allow the asset now to just dwindle away, and what happens then? There is a lot of criticism I read that the creditors are giving too much of haircut. But do they have an option? They don't have an option.
In
They
fact, I
want
want
to
to ask
close this issue as soon as possible. So
one
if they
last
feel, yeah.
one last question I want to ask both of you. For frivolous objections that are raised to various resolution plans, do you think there should be strong economic penalties for anybody who wastes more time in filing frivolous objections? Or do you think that is difficult to do?
I think one thing that must happen is that if a plan has been blessed right till the Supreme Court, which is the last court of appeal for you under the court, then anybody who wakes up after 6 months or wakes up after 1 year and wants to challenge that plan, then he has to deposit a huge money before even an NCLT admits or issues notice on that application. I'm telling you, it will help in a very, very good way. It will
But
reduce the burden of the NCLTs. Now because that is another practice which has started in tribunals. So tribunals will have to look into that also. Bhai, listen, if NCLT has looked into it, NCLAT has looked into it, the Honorable Supreme Court has looked into it, it's over now. You can't wake up after 6 months and say, oh my God, this has happened in this process, that has happened in this process. Then put your money where your mouth is and say that I'm ready to put this much of money. I was a better resolution applicant at that time.
point
So
very well
that's not
taken.
happening.
One more point on the haircut issue, one more solution. I don't know if it's right or wrong. To to reduce the haircuts would be to have a relook at 29A. Now, a person who has started the company, who's a promoter, he knows the real value. Now, under 29A, he's kept out. Some third parties, whether they're interested or not interested, they would just want to reduce value.
Correct.
And the companies are given it a haircut. If the promoter is also allowed to bid, at least the valuation will be fine. There are many cases where the promoter is willing to give more than the resolution applicant, but his plan cannot be considered. What happens is ultimately the banks lose. So 29A, I think, has worked itself out. Today, there should be a serious relook at 29A to safeguard these haircuts.
Point very well taken. So that's the end of part one today, which we did on the IBC code based on the matter being seriously taken up by Justice Pardiwala and Justice KV Vishwanathan. Now, this is before the Chief Justice of India, Justice Suryakant. I think something big and decisive will come from that bench.
Yes.
Because I think the Supreme Court realizes, and I think Justice Suryakant, of course, realizes the kind of situation that the IBC process in India is. We look forward to that. We'll do a part 2 soon on this, maybe in 8 or 10 days. Many more issues to be taken up as far as IBC is concerned. I would like to thank Advocate Mahesh Agarwal, Ma'am Ruby Singh Abuja for sort of taking out time for this special show we do on the observations made by Justice Pardiwala and also Justice K.V. Vishwanathan. Thank you so much for joining in. Thank you.
Thank you.